A few things to know about separation agreements in Saskatchewan. So to start off with, you can put whatever you want in a separation agreement. So even though the family home, for example, is considered family property, even if it was owned prior to the spousal relationship, and the equity in that family home is equally divisible between the parties, if the parties decide they want to do something different, an unequal division of family property or no division of family property, they can certainly agree to that and put that in the separation agreement. The second thing you should know, however, is that under the Family Property Act in Saskatchewan, there are two kinds of agreements. One kind of an agreement is one where you just reach that agreement between the two of you without independent legal advice, and that is recognized as an agreement. However, if there's a dispute in the future, it is one where the courts will listen to the evidence and determine whether or not there was a meeting of the minds, if there's any power imbalance, etc., to make sure that that agreement was actually fair and equitable. Now, the second type of an agreement is one that's called an interspousal agreement, and that's where each party has had independent legal advice. And that type of agreement is considered to be a final binding agreement because the law allows you to rely on the advice you've received from your lawyers. So if your lawyer didn't give you good advice and after the fact you don't like the agreement, the court is not likely to care too much about that, and instead would suggest that you would take up your complaints with the lawyer's insurance provider. The third thing you should know about separation agreements is whatever you might agree to between each other as spouses is not enforceable against a third party. So for example, you might have a credit card, a joint credit card, and you decide that the other spouse is going to be solely responsible for that debt. Now, if they don't pay that debt, the bank actually doesn't care what your agreement was between the two of you and will come after you for the payment of the debt just as aggressively as they will go after your spouse. And so it's important to include in your separation agreement this type of language that the person who is taking over that debt that's still in joint names is going to indemnify and hold you harmless for that debt, which means if they fail to pay it and you end up having to pay it, that then you are able to go after them to be reimbursed for the money that you paid on their behalf. Keep in mind, though, this is still a piece of paper. It doesn't have any magical powers, and so if you have to enforce it, that's a whole other process to follow through on. And it's a process that may see you having to go back to court and to utilize the sheriff or some other means to collect your money. And of course, everybody's situation is unique, and it's important to get independent legal advice to find out about how the law applies to yours.